In this session, we're going to be looking at copyrights, which is probably the biggest change in the last 100 years in the area of intellectual property, and that's because of software. Software today is worth a substantial amount of value, and certainly has given a nice proprietary position for companies and individuals who own it. So first of all, let's look at what a copyright is. The goal of copyright law can best be described as being set forth in the Copyright Clause of the U.S. Constitution. And I don't think any of you realize the Constitution covered copyrights. It's to promote the progress of science and useful arts by securing for a limited times to authors and inventors the exclusive right to their respective writings and discoveries. And I guess the best way of putting it is a protection for an original creation. It doesn't have to have any market value, and that's probably different. Trademarks, non-disclosures, trade secrets and patents usually deal with something that has got some value to it, where copyright can be just taking a piece of paper, crumbling it up, and if the way you do it is no one else has copyrighted. They say no two snowflakes are the same way. They could be copyrighted because they're different, they're unique. And anytime unique, it counts, even though it may not have any value. So if I paint a picture and no one can figure out what it is, it still could be copyrighted. Where if I'm talking about the other types of intellectual property, typically there has to be an economic value to make it so that you can support it. And I might note that copyright protection of art and music goes back for centuries. Drawings and manuals for manufacturing and software are relatively new. For works made for hire and anonymous and pseudonymous works, the duration of copyright is 95 years from the first publication or 120 years from creation, whichever is shorter. And these are newer rules that have been there. So we have author, if the author is identified, it's later revealed to the Copyright Office, in which case the term becomes the copyright life plus 70 years. So Elvis is there, still have a copyright on his music, and so does any other popular musicians or artists that have died within the last 70 years. Again, these are new rules that have changed drastically. Due to the success of the entertainment community and the growth in areas of computer software, copyright material is a big business today compared to what it was just a few 20, 30 years ago. Example, 2006, the value of royalties and licensing fees on exports was $120 billion, which is approximately equal to the value of our aircraft exports, which is $121 billion. So certainly when we talk about exports, I don't think anybody in this class, including me, would say royalties and license fees would be a major one in this country, and yet it is. With this type of value, considerable efforts are made to protect the copyright by the owners and licensees, as you can figure, and a lot of money is spent trying to obviously get around it because of the fact that it is very valuable. So therefore, we've always had people trying to take advantage of it, to use it for their own benefit. And again, such things as getting stuff off the internet and using it, it would be a copyright infringement. Let's talk about the financial planners in the copyright. The following are some of the contributions of financial planners in the copyright industry. First of all, we've seen articles and books on financial planning written by individuals, and that has a value. For example, I've known several people in the area around Cal Lutheran who are financial planner practitioners who've written their own books, and they give those books to clients and potential clients. And by giving those books out, they are shown as being an expert in that particular field. At the university here, we have a course that Harry Starn has put together that is based on the student preparing a book on which they become an expert, And if the student, after taking the course, wants to, they can publish the book and, again, give it out or sell it. I think the value of these books typically are going to be a marketing technique for your business, where clients go to you because you're the expert. You wrote the book on it. Preparing financial planning software. There's one of the ex-students here, Cal Lutheran, went into preparing software. He had a software background, and today makes software for financial planning. Another is creating unique and creative advertising slogans. Again, those seem to always work. Good gimmick is being unique and creative. Creating new budgeting or investment forecasting software. And finally, using licensed products are all examples for copyright. We have when employees develop copyrighted material, the company in many cases owns the material. And what you have to do is look at the written agreement between the employer and employee. And there's usually 4 situations in the agreement. One is where the employer owns anything developed by the employee. Sometimes they say within 6 months before employment and a year after employment. That's for the person who either has finished it up really when they were under employment, or left the company and then, quote, all of a sudden developed it, unquote. And that is a very common one, especially for the technical areas. Then we have the employer owes everything related to the business. Again, during periods have to be defined as to when, starting date, year after, ending date, whatever. Employer owns whether it was developed during the working time. Again, that becomes a burden on the employee really to show that they did it on their own time. And again, the period of beginning and end should be covered. And an employee is a licensee for a non-compete agreement. So I would say for financial planners, if you're working for someone else, you should be sure to make sure the agreement is reviewed with an attorney to protect you. And if your company, certainly you're going to have a different viewpoint and making sure the company protects everything, such as anything you develop within 3 months prior to the employment to the year or 2 years after the employment's over. And again, I wonder how many of you looked to see what you've signed up for, because I imagine if you're with a big company, you have signed something along this line. And if you're a smaller company, perhaps it'd be best interest of both parties to get it clear right now, rather than waiting till after you leave or the employee leaves and then uses something and the employer says, hey, that belongs to me, and then you have a lawsuit. And nothing's really gained by lawsuits except they making lawyers rich. Patents are the next one we're going to just spend a little time on, because it's not something that we would see really for financial planners in our practice. Our patents are granted by the U.S. government, providing monopoly for inventions that are able to have a commercial market value. So if it's something new, it has to have a commercial market value. It has to be a new idea. It could be modifications of an existing patent, and it could be new applications of a patent. All of them qualify. The United States uses the first to file method, not the first to invent method, for determining patentability, which is relatively new, which means I might have invented it, but if you get to the patent office before me, you got the patent. Again, it has to have economic value. I think that our new is fairly straightforward, and I like to take example of modification of an existing patent being a lawnmower motor and putting it on a little go-kart for kids to drive around at an amusement park. I've modified that motor from used on the lawnmower to being used in this little cart that the kids are driving. Or it might be a new application of that lawnmower motor. Instead of using it for a lawnmower, it would be used for a condensation machine. That would be a new application. So those are what common usage. If we take a look at the patents in our field, being a service industry, developing patents would rarely be related to our job. However, the written agreement on IP between the employer and employee may cover patents developed by the employee unrelated to the job, and that happens. In my career, many of the companies I worked for, even though I was not a scientist or a person who was going to invent anything, I had to sign an agreement that said if I invented anything while working with the company, even though it was not related to my job, I would have to give up the rights to that patent to the company. It never happened to me, but it actually happened to someone who I was working with. He came up with a patent on a way of calculating estimates of future costing. And it was I guess the best way of putting it was a mathematical equation that was patentable, and he patented it. He did it all on his own time. It had nothing to do with what he did at work, and the company took ownership of it. And there was a litigation between the two for a couple of years. And again, a lot of money was spent on attorneys, and eventually he lost and the company got it because the agreement he signed covered anything he developed while working as that company, irrespective if it wasn't related to his job. So you got to be careful of that stuff. And again, it's always good to have an attorney look at the papers you're signing when you go to work for a company. And likewise, from the company standpoint, always good to have an attorney check out and make sure it's good for you. Let's take a look at ethics and intellectual property. Owners of financial planning practices need to include ethics in their job description and department policies. Unless you're the owner of the financial planning business, most of the material covered in this module may have little relevance to you except the ethics issues that follow. The IP ethics, for example, is not to use other people's material without permission, which gets us to plagiarism. Plagiarism isn't just a problem at universities, but it's very big in the commercial world, probably bigger in the commercial world with economic value than it is at the universities, which typically aren't of any value. Financial planners can use material from books and articles and treat them as their own articles material for clients who are guilty of plagiarism. And one of the things I did when my practice is for things that were legal questions, I would have like what's community property or what is a joint venture. I had little cards where we took material from literature that defined what these terms were so that we were not practicing law. We were giving something from the common textbooks or common material found in the library, and we didn't tell them if it applied or not. We said that this is the definitions. And if it was a case where we took something that was a unique wording, it wasn't generic, we always gave credit for where we got it. That way, avoiding plagiarism. Now, it's common for planners to say that using the fair use doctrine, however, the doctrine is extremely limited. You can't copy a whole book, you can copy a paragraph, and it usually has to be a purpose for why you're doing it. Excuse me, and I think that for most financial planners, it really isn't worth the problems of trying to define between the fair use doctrine. Give credit where credit is due. The fair use doctrine consists of 4 factors: the purpose and character of the use, the nature of the copyrighted material, the amount and substantiability of the portion taken, and the effect of the use upon the potential market. And these are very legalistic, they're very subjective, and you're not going to get an accurate interpretation unless you get to a lawyer who is knowledgeable in the area. So if you go to a typical business lawyer, they can help you. Typically, you're going to have to go to a lawyer who specializes in IP, and there's quite a few of them around today, by the way, to see if what you're doing is correct. Another area we want to discuss is non-disclosure agreement as part of ethics. Typical planner has a non-disclosure agreement with their clients, with other professionals, and in most cases, not just many times, but most cases with the employer. In fact, I think it would be a good idea for all employers to have non-disclosure agreements with their employees. It should clearly call out specifically what is not to be disclosed. In other words, don't be generic, such as anything we discuss in the meeting. It should be things that are really significant to make sure that we don't be unreasonable in what we're calling non-disclosure, such as maybe a formula we use, or a presentation, or a script to use with clients. I was teaching a class one time, and I had students go out to car dealers, and one of my students, who was very shy to begin with, was supposed to come up with what the car dealers had as their pitch. And all car dealers think they give different pitches, but when you go and really listen to it, you can't tell one car dealer from another. But this particular lady went out, and she got called in the office of the general manager, was yelled at because he thought she was trying to steal his technique and that the firm used for getting clients. So she came back and told me, and I called the company, and I actually went down to talk to the general manager and said, they were just trying to see what company's doing. I said, my position is you're all basically saying the same things in your approach to selling cars, and that's what we were trying to see if that was a true statement, and in our opinion it was true. There wasn't anything really unique. Well, that was, to him, he thought his uniqueness, and certainly I would say that from what we were able to see, it really wasn't something unique. And a proper non-disclosure would cover the sales techniques and closures discussed in the meetings. That would certainly be an area to be covered. What should be included in the non-disclosure agreement? First of all, the parties to the agreement, an employee and employer, or maybe it might be a client in the company, specific subject matter that's proprietary. And if you don't know what's proprietary, then you can't have an agreement, let's face it. The length of time it's treated as proprietary, and there should always be a time limit, that may be 10 years or 20 years. A type of marking on data that's be considered proprietary. The right and obligation to disclose under the court order should always be allowed. In other words, a court order should allow you to be able to disclose it. And the remedies for not complying with the agreement should be called out. And again, I think both parties have to sign it, obviously, and date it. But it's a good idea to have it in writing, even though you may be in an employee-employee relationship. Compliance to CFP Board Standard of Ethics, which is covered in a relationship with clients under the board's ethics standard to be treated as proprietary, and that was covered the first week. Major ethical issues resulting therefrom include but are not limited to, trying to make it sound a little legalistic with the not limited to, discussing client with non-authorized professionals or associates. That's not only true for financial planners, that's true for people who prepare taxes. One of the few requirements the IRS has for tax preparers, you don't talk about a client and their tax return with anybody who isn't approved ahead of time by the client. Same type of rule. Not protecting client-owned data in a secure manner so that no one can get at it. And now I'm not saying it has to be put in a safe, but a locked cabinet should be a normal place for it, or certainly not take your data into another client's office or another client's home, including client data and emails that was not protected, not performing real due diligence, which is a big problem, and providing as fact information that's really opinion. And we continue on when leaving the firm. Most firms have a policy in place that's signed at the beginning of employment covering what a planner can take or cannot take when they leave the firm. For example, can I take the database of clients? In most cases, no. Letterheads, no. Business cards, no. Do not compete agreements would be included. And finally, company material marked as confidential material would be excluded. And then finally, what we'll get to is the student must understand the following after completing, should understand the following after completing this module. Ability to identify what is a trademark and other intellectual property, intangible property. Property used in non-disclosure agreements. Let's start over again. Properly used non-disclosure agreements. I had the same speech teacher as George Bush. Understanding there is a substantial issue in the misuse of IT intangibles, and it's getting worse every year. And being able to describe what materials should be not taken when leaving an employer. And with that, we are finished with our ethics discussion.